This starts as a communication dispute, but the way Mr. Hall frames it matters. He isn't asking the court to referee one annoying pickup. He's pointing the judge toward an existing parenting agreement and presenting the problem as something ongoing that he hasn't been able to solve privately. That's a much stronger position than simply walking in angry about an ex.
Versus Brenda Fournier. Fournier.
Present.
You're on that one? Daniel Hall is here,
Yes,
and
sir.
Brenda's here. You're both here.
Okay. Good afternoon, Judge. Can you hear me?
I sure can.
Good afternoon.
Motion to enforce parental agreement. Who filed that?
That would be me, Your Honor.
Okay, hold on. Oh. So what's the problem, Mr. Hall?
Good afternoon, Your Honor. Thank you for your time. I'd like to thank you for your time first.
That's okay.
I have a parenting plan with Mrs. Hurley. And the issue I bring forward today has been an ongoing one. It's something that I'm not sure how to go about resolving, and it's two-part. The first is page 2 of the parenting plan, signed by both Ms. Hurley and myself, outlines the responsibilities of both parents. One of these responsibilities is letting the other parent know about proposed schedule changes in a timely manner in advance. And Ms. Hurley repeatedly fails to adhere to these guidelines. One such example recently is she made a late change to the schedule. I agreed to it, and I waited at the school for our son, and he didn't show up because he hadn't been told of these changes. And when I went to pick him
It
up,
wasn't fair to communicate it to you. It was fair to communicate it to the child.
yes,
How old is the child?
and many such cases. He is 14. He'll be 15 this year, in just several days from now.
Okay, I take it, Brenda, that your last name is now Hurley?
It's been Hurley since 2019, Judge. My
Okay.
legal name is Fournier Hurley, but I go by Hurley, which I would like to get referred.
It's fine, and that
Okay.
is what we call you. So what do you have to say?
What day is Mr. Hall referring to when he
Oh,
went
ma'am,
to?
that isn't how it works. He says that there are repeated instances of failure to communicate, and it creates a lot of confusion and inconvenience. And
Okay. We when our parenting schedule, when we talk, I have sent dad text message of saying, this day and time does not work. Do you mind if we change? For the most part, he says yes, no, we agreed or disagree. And for example, when he has family visiting, we change on the weekends. That has helped, that we both agree on.
do you not understand what he's saying today?
I do understand.
Okay, he says that at your end, that when you want to make changes, you often don't let him know till the last minute, or you fail to tell the child about it, so that it creates confusion.
I have text messages where we both have agreed on time changes or date.
That's not the issue. He just gave an example of a case where he agreed to the time change, but you didn't inform your son, and as a result, he showed up to pick him up and he wasn't there. So it's not it's not a world-ending issue, but it's an issue that creates inconvenience. And I will tell you both, generally speaking, that a parenting plan is supposed to be a guideline. You're both supposed to be flexible, not only to accommodate each other, but to accommodate your son. For example, and I don't know if your son participates in, let's say, soccer, just for the example. If he's got a game or a practice and it falls on that at the time that an exchange is supposed to occur, well then the parent that could easily agree that, okay, instead of me exchanging at the designated time, I'll pick him up when practice is over. You know, that's what you do as parents. It's part of co-parenting. But it's important that when changes are made, that all three of you know about it, so that we don't have to do things like this.
The judge's response here is measured, and that's significant. He doesn't inflate this into some catastrophic parenting failure. He calls it an inconvenience, then immediately explains why the underlying habit still needs fixing.
Does that make sense to both of you?
I understand.
Yes.
And you understand, Mr. Hall?
Yes.
All right. You guys, this is still your son. And by that I mean both of you. And the bottom line is, you have to do what's in the best interest of your son, and you two and your son all need to communicate so that if it's pickup time, he's there at the appointed place and time. You know, that you're not that morning saying, oh, by the way, I forgot to tell you that my family's coming over tonight. Can he stay until 8 o'clock tonight? Because that's a little late. Now, if you text him and say, I just found out about the fact that my family's coming over for dinner, would it be okay for him to stay late? That's fine too. But if you have advance notice, then you communicate with each other in a timely fashion. All right?
Yes, I understand.
Okay. Mr. Hall, is there anything else you'd like me to do or say today?
One other issue I would like to talk about is it was actually that same day when I went to pick up my son from her house, because I thought that was the plan. That's the plan that we had communicated earlier, is that I was supposed to take that weekend. So she was at work. I thought I'll go pick him up and no problem. And she called the police on me and had them come to my house looking for me. And another day, she told the school conflicting information when he was sick, which prompted a wellness check on us as well. So she's been using, this isn't the first time, it's at least 8 or 9 times in the last few years that she's used officers. What I feel like as a bludgeon, basically.
Okay, I will tell you what. It is never, ever appropriate to call the police, because you two are having some sort of misunderstanding or disagreement about parenting time. If for no other reason, then it's a traumatic experience for a 15-year-old to have the cops show up because his parents are having a spat. And I will tell you, if that ever happens again, now, I shouldn't say that. If, there is an incident of domestic abuse, absolutely call the police. But short of that, if one of you files a motion and brings it to my attention that I went for pickup time, we got into a disagreement and she called the police, and I'm just saying she for an example, then you bring it to me and I will modify the parenting plan, and one of you is gonna lose some parenting time. Do you understand?
I understand, Judge.
Yes, Your Honor.
Whatever's going on between you two, when it comes to your son, it doesn't exist. Because even if you don't like each other, you better cooperate when it comes to your son. Understood?
Understood, Judge.
All right, that's it for today. I hope that if I ever see either one of you again, it's at Woodman's. Okay?
Yes.
All right,
Thank you
Your Honor.
both.
The final exchange between the judge and the parents is less about affection than discipline. They don't have to like each other. They don't need to repair their personal relationship. What the court expects is enough cooperation to keep their conflict from spilling onto their son. That's an important boundary because separated parents sometimes treat communication as optional once the relationship is over. Parenting doesn't work that way. The personal relationship may end, but the shared responsibility continues. Both parents say they understand, which matters because the judge has now made the expectation extremely clear. If similar conduct reaches the courtroom later, claiming confusion about what was expected becomes much harder. The judge ends with humor, hoping their next encounter happens somewhere outside court. It's a light exit, but underneath it sits a serious message. Solve ordinary parenting problems, like parents before the court has to solve them for you. The post-hearing criticism raises fair questions, but this is where viewers should separate what feels suspicious from what the hearing actually established. Ms. Hurley's reliance on texts doesn't fully answer why the agreed schedule apparently broke down, and calling police over a misunderstanding naturally invites scrutiny. But labeling her conduct intentionally vindictive goes further than the evidence clearly proves here. Intent matters, and we don't get enough information to confidently assign one. The stronger takeaway comes directly from the judge's approach. Reduce unnecessary escalation, communicate clearly, and don't make the teenager absorb the consequences of adult conflict. The possibility of losing parenting time gives that message real weight. This hearing wasn't about identifying one perfect parent and one villain. It exposed how quickly ordinary coordination problems can become serious when communication fails and outside authorities get pulled into disputes that should have been handled between the parents.